So question 2 brings us on to the purpose of the General Data Protection Regulation. This is a very new piece of legislation that was brought in to the European Union while we were still a part of it. And the idea was it replaced the Data Protection Act that we originally had with a brand new one. Now, the GDPR is actually going to be cancelled in the UK. Now we've left the EU. However, we will be having a replacement version of something very similar that will probably be given a very similar name. As it stands at the moment, the GDPR will still apply in the UK, as all European legislation does, until the UK makes a change to the way that it's working. It is possibly the strongest data protection regulatory piece of legislation that there is in the world. The idea of it is that it increases the privacy of individuals, the so-called data subjects, and the way it does that is because they cannot share that data without your express right. It extends the EU residence data rights, so it extends the rights of where we can actually have our data stored and how we expect it to actually be stored and how we can expect it to be protected. Provides authorities with powers to take action against any organisation that breaches the regulation. This was the big one because the amount of money that they can actually enforce fines with is huge, depending on how severe the leak of data is. The biggest leak of data to date, I believe, is British Airways, but they didn't actually get prosecuted to the full extent of what the law would allow, because that would have actually moved into billions of pounds. Ensure that all new businesses that use personal data follow the regulation. If you create a new business, you have to actually register with a data controller to say what personal data you are going to store and why you're going to store it. And at any point where you are audited, you must make sure, obviously, that you are not storing any other personal data for that purpose. You must also make sure that you actually get rid of any of the personal data at the point where it stops becoming useful for your particular company. So if you've got old client accounts or anything like that, they need to have that data removed at the point where they stop becoming a client. Ensure that businesses outside the EU collect and process the personal data of EU residents according to regulation was another really strong part of this legislation. Before this legislation, we had something called the Cold Harbour Agreement with countries like America, which generally have very lax security laws. It's one of the reasons why companies such as Facebook are allowed to take quite so much of your data. When information is actually stored on a server in a different country, the rules were very different. Now with GDPR, you may find that certain American websites don't actually allow you to access them if you are within the EU, because they cannot guarantee that they are protecting and collecting your data as per the GDPR Act. And a lot of newspapers, etc., have this as a problem. One of the most visible parts of GDPR for most people when they're using the internet is the requirement now to be told that you're having a cookie added to your computer. This "yes, I accept" boring warning that appears at the bottom of nearly every website. The reason for that is because it's actually storing a piece of data on your computer, which it can then use to track you across the website as you travel across it, or in fact across the internet if it is a marketing cookie. And so when you've ever seen, you've searched for a trampoline on eBay, and suddenly every advert that you see on the Daily Mail is for trampolining and trampolines, you know that that's being caused by a fact that a tracking cookie has been put on your computer. Question 3 is obviously also on this page, and you can see that GDPR applies to two different groups: data controllers and data processors. There are actually three different items that we use for the GDPR. We talk about a data subject as well as the data controller and data processor. And the data subject is the person the data is actually about. So a data controller is a natural or legal person, public authority, agency or other body which decides how and why personal data will be processed. I always imagine the data controller as someone behind a desk with a big cigar, in sort of the classic view of someone who worked in government in the 1970s in some programme like Yes Minister, and they are the controller, they control everything. The data processor is a natural or legal person, public authority, agency or other body which processes data for that controller. They are the company that are actually collecting and holding on to that data in order to be able to supply that data to the data controller when required. But also they have to store this data because otherwise they cannot do the job properly for the work that they need to do for that data subject. They should never, as I've said previously, store any form of personal data that is not required in order to actually accomplish the work that they do. So page 6 shows an example of this about a plumbing company, and it shows that the payroll firm actually becomes the processor and they become the controller because they're signing a contract with payroll because the payroll is actually storing all those personal data for a particular company. So the data controller in this particular instance is the company that is outsourcing that data, and they need to be keep track and keep check on the processor to make sure the processor is fulfilling all their guidance legally. It is actually up to the controller that the legal requirements rest, but obviously they could then cause a problem with the processor. There's a little key fact there as well. Online advertising in the UK generates over 10 billion in revenue by monetising people's online activities. It's been calculated that if you have a Facebook account, you are earning Facebook around about £500 a year just by having the account present and putting your own data upon it. So it shows you just how lucrative some of these different ways of storing your data actually are. Question 4 is looking at the key principles of the general data protection regime. So GDPR has a series of different key principles that you must include in your own policies and procedures to stay compliant. So these are updates from the original Data Protection Act, but most of them actually do follow what the Data Protection Act used to say in the first place. So the first principle of lawfulness, fairness and transparency. The first one's really important. Everything is opt-in now for data storage. So data subjects need to be told what data processing will be done. It has to then be processed in the way described to the data subjects. You must tell them why you need that data and what you're using it for. And those processing must meet the tests described in GDPR. So you must actually process in the correct way, storing the data using encryption and making sure that only the people who need to have access to the data actually do have access. The purpose limitation is the same as the Data Protection Act, where data must be collected for the specified, explicit and legitimate purposes and not further processed in a manner that is incompatible with those purposes. So you have to say exactly why you're collecting this data and how much of that data you're going to collect for that purpose, and that needs to be communicated with the data subject. At any point they can actually ask to see exactly what data you actually hold upon them, and other than a nominal admin fee you must supply this information. You can process for archiving purposes in the public interest, scientific, historical research purposes or statistical purposes. The reason for this is all those different stages, it's considered that if it's for statistical purposes or research purposes, there shouldn't be any necessary individually identifying data. For historical research purposes, there may be individual data that is available and knowledgeable, but it goes beyond the constructs of the GDPR. Data minimisation. You have to make sure that only the data that is relevant and limited to what is necessary in relation to the purposes for which they are processed should be gathered. So you can't gather a whole load of information that you don't necessarily need at the moment but might need in the future for your particular business. You have to specify exactly what your business needs now and make sure you only collect what that is actually asking about. If at any point you are found that you are collecting any extra information, you are breaking the GDPR rules and regulations, and you must specify exactly why you are collecting all this data to your data subject. The accuracy of the data is really important. Inaccurate data actually breaches GDPR in just the same way as having too much data. It must be accurate and kept up to date, and every reasonable step to make sure that anything inaccurate is erased or rectified. So if you ever see a problem in your personal data, or a data subject sees a problem with their personal data, they should be able to inform you immediately and have that data changed. Storage limitation. Data must be kept in a form that permits identification of data subjects for no longer than is necessary for the purposes of which the personal data are processed. As I say, if you lose a client from your company, you have to get rid of any data that's actually stored on them for as long as you don't need that information for whatever purpose. The police have been involved in a lot of this in recent years with their DNA databases. They've had to put in limits on how long they can store database for non-suspects, of a non-suspect's DNA. So if you're not prosecuted for a crime, the police actually have to get rid of your DNA. I think it's within about 2 years. Integrity and confidentiality. Data must be processed in a way that ensures appropriate security, including protection against unauthorised or unlawful processing and against accidental loss, destruction or damage, using appropriate technical or organisational measures. These sorts of things they're looking at is that if any work is taken onto a portable device, it must be encrypted. So, for example, if someone accidentally leaves a laptop on a train, no one can actually access the data that's on that laptop, which could be considered of personal nature. Every system should really be password protected, and every person that has a role within a company should only have access to the data that they actually specifically require for that role. They should never be given any extra information that they don't need to have access to. This includes any databases that might be stored for any particular reason, but also any files that might be stored on a particular service. Technical measures include encryption. Organisational measures include policies, and making sure things are not unauthorised or unlawfully processed means you must be secure to the outside world as well. Whether that means keeping physical backups in safes or in secure storage elsewhere, you are responsible for the integrity of that data. You are also responsible for making sure that data does not get lost. So you are responsible for making sure that there is a backup of any data to make sure that any requirement for the business cannot then lose that personal data in such a way that means that they cannot then perform that job properly. The organisation is accountable. They are responsible for complying with GDPR and must be able to show compliance when asked to do so. It says if asked to do so, but the answer actually, or the question should be when asked to do so. Compliance includes creating and implementing data protection policies, creating contracts with organisations that process personal data, reporting personal data breaches, and putting security measures in place. A lot of companies think that GDPR means that they're going to be fined and sued every time there's a personal data breach, and that is not the actual case. The ICO that is responsible in the UK is actually a very supportive company, and if you've had any form of data breach, you should inform them immediately, and they will actually do their best to try and help you mitigate the breach as quickly and as much as possible. A lot of big companies choose not to admit personal data breaches until they get found out by some form of report that comes out in the media, and a lot of them actually get sued for this particular purpose.